up in another committee. So we're going to go ahead and get started and invite Senator Fitzwater forward to present his Senate Bill 801.
Thank you, Madam Chair. Members of the committee, I get this big peppermint in my mouth, so I'm really sorry. It's going to be fumbling around with my words. I'm here to present to you all Senate Bill 801, and I'm very proud to have two of my three daughters and my wife here. Part of the reason there's even a genesis of this and that I'm carrying a bill like this is because my wife is a licensed professional counselor, which I've said, I don't know, 1,000 times, so most people in here have heard that. But she works with foster care and adoptive children, and so just really love her perspective on it, and this is why we as a family are passionate about it, not only because of her work here in mid-Missouri, but because of our work as senators, as we hear cases coming in where we see the system failing kids, and we're traumatizing kids on a daily basis with a large number of foster care kids, a system that's way too slow getting them to permanency, giving them some stability, a system that is continually traumatizing kids. And so Senate Bill 801 is meant to be a form of a shell bill, as the chairman, Senator Carter, and I have talked through. What do we add to a bill like this in the foster care space that will really fight for kids? And so this is the start to that, and I hope we add provisions to that as those on the committee see fit and those in the Senate see fit, those in the legislature see fit. But the first two provisions, and there's really kind of three pieces to this. The first two are, one, giving children in foster care system the right to counsel. Really the underlying desire, and the chairwoman and I have talked endlessly about the need for tension in the system, for more advocates on the side of foster care kids. So the desire is, as these problems are taking so long to get through the system, and have some witnesses will testify that personally, as they go through the system, we need more people advocating for children and taking their case into the court system and asking judges to make determinations for permanency. And so right to counsel is really this idea that if you give individual foster care kids representation, that they're going to have somebody going to bat for them. And that's the first kind of big desire of this shell bill. The second piece is, what do we do with judicial officers? And there's a lot, you talk to one judge, they'll say they should sit on the same side of the bench as us. And some others will say that they should be separated and held accountable from a different entity in the state of Missouri. I personally feel like judicial officers should be overseen by a different entity than the judges that appoint them. And I think that's important because that's another piece of tension in the system. We need to have people going to bat for kids that aren't on the same side of the judicial circuit that hires them. And there are some rules that prevent a judge that hires a judicial officer to be on a case with a judicial officer, but there's still that sitting on the same side of the table making decisions for a kid's life that we've witnessed firsthand, not only in my office, but my wife and her practice, and other senators across the state of Missouri, with judicial officers not having that independence that we would really love to see. And so this is a conversation starter. I think, again, this is a shell bill. So I think there are people going to come up and testify against this bill because they want to see changes. The judicial officer language basically takes all of the judicial officers and all their supporting staff, and so it's, the fiscal note is huge because of that. I'm more than happy to have changes on that. I think this is a work in progress, but what needs to be figured out is the nearly 13,000 kids in foster care are moved towards permanency, and it's not a multi-year process to figure that out for kids. They need stability, and on a daily basis, and this gets emotional for us because I'm seeing kids traumatized from watching it from my office. We see it in my wife's office. We see it in other senators' offices. Chairwoman, you last year helped me on a case wanting to drive to our district and file a brief. I mean, there's a lot here, and so we've got to do better. And so there's a lot of ideas for that, and welcome any ideas to come forward to figure out how do we create a foster care system that matters for our kids.
Thank you, Senator. I appreciate it. For the senators who are on time at the committee, starting when we said upon adjournment or immediately after, I just wanted to let you know we went ahead and started as a subcommittee because the senator has other obligations. He's got guests that he's presenting and gubernatorial appointments, and so he's needing to be excused. So rather than pause and take the role because he's on a tight time frame, I thought we'd open up for questions and then do that kind of administrative stuff after he leaves, but before we hear witnesses.
And they're working with me up there, so I'm not in a huge hurry, but
Okay.
glad to answer any questions.
Senator Moon.
Thank you. I see your entourage is only four-fifths complete here.
Yeah,
You're
yeah.
missing
The youngest
quite a
is up.
component.
She, we homeschool our daughters, as you know, and
Yeah.
actually one of them, the one that booted you out from your room, as you were a tenant of ours for years and years, she's here. But having our daughters here see the process is really a lot of fun. And actually, my wife will be the first witness on this bill. Really excited for her to give a little perspective on what she's experienced.
And surprisingly, the booting of my residency doesn't have any effect on this bill.
I hope not, but it's yet to be seen. There's still time. So.
I do have a question, though, with regard to the reports that are reported to the division, Children's Division, when it includes abuse or neglect, separation, dissolution of marriage, and those things. Is the police department and other who are getting reports, do they not already report to the division? They should. So on these cases, they're very sensitive, and so the ones that are the most sensitive, we just want to make sure that a kid's getting represented, and so that language is in there for that reason. Okay, and I do wholeheartedly agree with your point about dividing the oversight. I think that's important, so appreciate that part of it. Thank you for your answers.
Yeah, thank you, Senator.
Other questions for the senator? Mrs. Fitzwater, would you like to come up and testify? We'll take testimony in support and then in opposition and then for informational purposes only.
Get out of here. Yep.
And everybody needs to remember to fill out a witness form, please. So you can do that after your testimony, but.
All right, yeah, thank you for having me today. It sounds like you guys are going to hear a lot of really important information about the different angles of needed change in the foster care system. So I struggled a bit discerning what I would like to add to that wouldn't be redundant. So I just started just real quick last night. I was like, I'm just going to think back over the past year and a half just of doing play therapy. And just thinking about just this last year, I think of the hours of heaviness I've experienced over just one family that stands out to me. I think about the heartbreak of really good foster parents when after over 2 years of these kids in the system, the judge granted the mother an additional 6 months to write a letter to these kids when she had had over a year to do so, which in turn threw everything up in the air, resulting in a 6th placement for the little guy I was seeing that was barely 7 years old. He'd been in, this is his 6th home. We had made some significant gains in therapy in the year preceding this change in placement, as stability, safety, and love had begun to reroute some neural pathways that had created a framework that this little guy was unloved, unwanted, and that the world is unpredictable and unsafe. So we know that the first 5 years of their life is crucial for attachment and successful relationships going forward. And so when I say rerouting neural pathways, there was a framework that had already kind of been established in this little kiddo that there was something wrong with him, that he keeps getting moved from place to place, that, the world's kind of unpredictable. And so those new neural pathways can be created because thankfully God made our brain neuroplastic, but it's a lot of work. When it doesn't happen in the critical time period of those first 5 years, it takes thousands and thousands of repetitions of good things to change those neural pathways. So I was seeing some good increase of just some new pathways being formed, some good, violent play being shifted to nurturing play. But then to see another upheaval, another new placement after being in the system for almost three years and the subsequent fallout of this kiddo's nervous system. I've had some passionate thoughts and feelings during this time at the overreach of authority, in many cases by some caseworkers or juvenile officers. I have fought to understand what seems like a lack of accountability of judges to the law at times, and just fought to understand judicial rulings that sometimes seem so counterintuitive to what we know about trauma in a child's brain. I have not understood why my and my colleagues' opinions are often sought out, but they seem to only be heeded or taken in consideration in certain instances, or if they follow along with what the judge and the caseworker has already decided was going to happen, that's when our advice is taken. Otherwise, it seems like it's disregarded. And I know this is not across the board in every instance. You're likely going to hear, you've heard of some of these issues. You're likely going to hear or have heard that research has shown that the first 5 years of a child's life determines healthy attachment and greatly impacts the trajectory for years to come, and that trauma actually alters and changes the brain. I sometimes wonder if people making the decisions for these kids have true understanding of these basic facets themselves. I've seen a child's violent play switch to nurturing themes as he begins to heal, only to see their world fall apart once again with a new placement due to the length of time in the system. I've listened as they compare the different beds they've slept in, how soft the pillows are from one house to the next. So trauma-informed care is paramount if we really want to help kids and have a system that prevents further trauma rather than perpetuating it. We need policies and professionals and the professionals involved to truly understand trauma, what it looks like, and make decisions where preventing increased trauma is a priority. And again, I know it's multifaceted and everything you do has a bunch of ripples in the opposite direction. But just from my little bit of experience to myself, I feel like there needs to be accountability for the professionals involved where personal vendettas and opinions, egos don't go unchecked, where foster parents aren't punished for raising honest questions, where bio parents who aren't perfect but have done good work receive their kids back but aren't given a limitless time frame to do so. I'm for reunification, but there needs to be time frames that are adhered to, or just the law being followed. I think that we have a law where it's not, we have laws where it's not supposed to go on and on, but yet it does. So I'm not really understanding why that keeps happening. The foster kids need a consistent person who knows their case well and is going to bat for their interests all the way through. Like, it's like a revolving door of people. I sat on family support team meetings, and there's so many people there, but then that person may be gone, or maybe switch the next time. And so, and even with this recent case, there was a guardian ad litem, and she was like adamantly against some of the stuff that the caseworkers and the judges were doing, but it seemed like her voice was faint among many. And I'm just confused of why that is. And so it seems like there needs to be someone who fully understands trauma, who's fully representing a child, and can kind of go to bat for them throughout so this process is not just endless. So yeah, and I mean, I think about trauma training, but I also think it's hard to make that, it needs to be done well and taken seriously. And I know there's a lot of ways, it's hard to enforce that. So that's all I have for right now.
Thank you for your testimony. Does anyone have any questions for this witness? Go ahead, Senator.
Hi. Thank you. I'm Senator Washington. I'm in Jackson County, so we have a lot of folks. Now, are you actually a guardian ad litem or a foster parent?
No, I'm not. I'm a play therapist.
Okay.
I'm a licensed professional counselor.
I know what they are. My grandson has to have it. And
Yeah,
he uses the words against us. If you're watching a football game, you get excited, he'll go, oh, just breathe.
Yeah.
Unless it's Mizzou, so he's now a Mizzou fan. My question is, I understand your concern about the length of time with reunification. I think it's 22 months is when it's supposed to have a plan. However, considering that there's a large number of my constituents that are in the foster care system, what if you don't have an adoptive potential parent, what is your suggestion to do instead of extending it to try to help for a parent that is moving along the proper, moving along, doing what they need to do to be reunified? If we end that at 2 years or whatever, and we don't have a permanent place for the child, what is your suggestion?
Well, I think that often what's happening is that parents are doing like bare minimum. And I'm for reunification. Like, I think that is best for a child to be with bio parents. But what seems to be happening so often is that there's just like tiny little incremental steps. There needs to be something where it's like, okay, we need some real progress going forward. If you want to be reunified with your child, then let's see this actually happening. And it seems to me like we could have things resolved pretty closely.
No, I agree.
And
we do that a lot
honestly,
in Jackson County. So.
Yeah, and honestly, I think there needs to be a lot of shifts in the system. I don't know if you've ever heard of Safe Families. There's a model that they're creating right now where there's a system of people that aren't even necessarily in the like foster parents, but other kind of, they play those similar roles, and they come in and try to just help alleviate some of these immediate needs. And so I think if you could integrate a system where there were other people walking alongside these parents that are really trying to make meet the goals and do the steps.
Okay, I can talk to you a little bit more offline, because in Jackson County we do that.
That's
They have a whole circle of folks, and if they're not moving forward, like as a lawyer, if I'm assigned a case, I have to take it whether I want it or not. And if my client isn't doing, for instance, if they were drug addicted, which we know is a disease, but if they're not being tested or they're not coming off, then we move towards termination of of those parental rights. So I'll be happy to chat with you offline, because I know as a lawyer that everything is not uniform in the state,
right.
But for those counties that are doing a great job, then maybe we can kind of model that.
Right.
Thank
and
you.
I think just that, there's just, it seems like so often there's just not a lot of accountability to stick to the time frames. Like I just, like with this one case where parent had over a year to write a letter, didn't, and the judge like, okay, here's another 6 months. Well, in that 6 months time frame, the foster parents are like, well, this is all we're talking another probably year by the time this if we're just gonna start the process in 6 months. So it just results in just like this extended amount of time, where I think if we just keep giving parents more and more and more time, we're prioritizing them, and we're not prioritizing like this, the neural system of the child and the trauma that they're continuing, So
And I was going to be done, but I agree with you to a certain extent, except for my constituency is the largest number of children that are in foster care.
Mm-hmm.
And if there is anything that can help Black and brown children get back home, I don't care how much time it is. I'm not saying 5 years or whatever, but I've always felt like 22 months is too short. So if I have a parent, for whatever reason the child was taken away, and in 22 months they may not all the way be there, because I live in a community where I've seen drug addicted people. You may not be able to be 100% clean, but if you are moving towards what the courts have told you to do, and you are doing those things to be a better parent, I don't have a problem extending it for 36 months or whatever the case may be, because if there's not an adoptive potential out there, then my children that look like me, they go to group homes, and then that leads to homelessness and dropping out of high school, juvenile detention, prison. So to get them back, I have a cousin that's a social worker in St. Louis. She firmly believes that every child can have somebody out there in the family that will. I don't agree with her, but that is her job. She works for the Wendy's Foundation, and her job is to find foster children, adoptive parents. And this girl will go all across America to do that, and she has. I've driven to places that I shouldn't go. She's gone to Wyoming in her own car. So I do think that it does help if they can be with their family, if we can get the family back. Mm-hmm. That's not always going to be the case. Yeah. But I don't want to restrict someone who already had an undiagnosed issue, which is why their children ended up in foster care in the first place, and then say, hey, well, you only got this short amount of time to get your life together, or we're going to snatch your kids, which is frankly going to cause more emotional and psychological damage to the parent and the child. So I understand what you're saying about it seems like we're going for the parents, but I know you've heard the saying that the strongest family is the mother. If the mother's not strong, the family can't be strong. So we have to make sure that we are helping parents to the best of our ability and the best that they can be helped, because if we don't, then the kids won't be helped either.
Well, I agree with you. I think we have to help parents. I just think that so often the movement is very, very slow, and then we just keep extending it, and I don't think that's helping anyone. I think we have to, if they're really doing some significant work and they're making huge gains, that's another scenario. But if it's just that we're just eking out a tiny little bit incremental things just in time for the court, deadlines and things like that, that's another story, and I think that there's a lot of instances where that is happening a lot. And so I agree with you. I think that, if we can work it out, families should be together, but there needs to be some accountability within that, within the system. And I think that ideally, if we had programs where we could alleviate, so it's not just, you know, triage trying to stop the bleeding all the time, but we can help, okay, you need this assistance. And like I love the Safe Families models, and I know they've worked alongside state legislators and some legislatures in some states where people are stepping forward and taking different needs off families so that they can deal with a crisis and then integrate, you know, children back. So it's multi-layered. There's no one specific answer. I do agree with that. So, yeah.
Thank you so much. Are there any other questions for this witness? Thank you so much for being here. We're going to briefly move out of a subcommittee in order to take roll and call the committee into order. Madam Secretary, please call the roll.
Senators Coleman,
Here.
Carter, Arthur, Gannon, here, Moon, Thompson Raider, Washington.
A quorum having established, we'll move back into the committee hearing on Senate Bill 801, seeking testimony in support of Senate Bill 801. While you're getting situated, can I ask for a show of hands, who's here to testify in support of 801? Okay, and who's here to testify in opposition? Okay, great. So we have no time constraints. We're doing great. I just wanted to make sure we have a lot of people in the room, and I didn't want to worry about getting to everyone. Please proceed when ready. Thank you.
Thank you, Chair Coleman, members of the committee. My name is Kendall Seal. I'm Vice President of Policy for the Center for the Rights of Abused Children. I'm also a Missouri lawyer. The lives of abused and neglected children are the most impacted by the child protection system. Consequently, children should have a meaningful
Mr. Steele, you have a voice that carries. Do you mind scooching the microphone just a little bit away? We're getting a reverberation. Thank you. Sometimes people project too much and sometimes not quite enough. Thank you for adjusting that. Thanks.
Now? Great, wonderful, thank you. The lives of abused and neglected children are the most impacted by the child protection system. Consequently, children should have a meaningful opportunity to be heard, have their position represented, and have their rights and liberties protected. To accomplish these goals, the Center strongly supports passing Senate Bill 801 to afford every child in care a client-directed attorney. I'm going to talk about just my argument in support of this position. The fundamental life and liberty interests of abused and neglected children are at stake in dependency proceedings. These proceedings determine whether they can go home, whether they will see their siblings, whether they will be adopted or age out. These decisions have lifelong consequences, not just for them, but for our society as a whole. We often hear of youth who have, or are, experiencing foster care lamenting the lack of voice. Decisions are made about and for children, often with little consideration for their wishes or a sense of what fundamental ethical obligations are owed to them. They need someone who centers them and is in their corner fighting for their rights. And the system we have needs to be held accountable for their safety and well-being. Missouri can take a significant step toward affording children a voice that they deserve by shifting to a client-directed attorney representation model. Client-directed attorneys would be ethically bound to center the child, represent the child's position, and zealously advocate for and protect their rights through the duration of the process. Children should have such an advocate from the moment the state is involved. Point one, our current GA model of representation in Missouri often leads to confusion. While state law may seem to imply that GALs are obligated to represent a child, GAL standards clearly distinguish the roles of a lawyer for the child and a GAL, despite some local rules that may attempt to circumvent it. GAL standards reinforce that GALs do not represent the children's position, but conduct a so-called independent analysis and advocate for what they believe is in the children's best interest. Specifically, GALs in Missouri must advocate for what they consider. While the review may consider a child's wishes, the GAL is not bound to advocate for that position. The GAL's ethical duty is to the court to represent an alleged independent position rather than to the child. This amounts to advising the court in making the best interest determination, with little to no safeguard or cross-check. Additionally, because GALs do not serve as lawyers for abused children, they generally have no ethical obligations to the child, such as an attorney-client privilege and zealous advocacy for the child's position. It's this conflation of the statutory provision describing legal representation with the GAL's duty to represent concept, the best interests. That's where the confusion lies in the Missouri framework. The bottom line, most children do not have someone actually advocating for them, giving them a voice, and holding the system accountable. Point 2, children's rights cannot be effectively enforced without client-directed attorneys. Children in foster care should be guaranteed rights, ranging in nature from timely permanency in a safe and living home to placement with or ongoing contact with siblings. And for some, it's focused on reunification with their parents. Any rights that the state of Missouri recognizes for children in foster care cannot be adequately enforced if the child does not have an attorney who is ethically bound to protect their rights. Even if a GAL meets with a child, discovers their wishes, the GAL is under no obligation to them. The GAL must advocate for their position rather than the child's. Finally, Senate Bill 801 will reduce confusion. It will promote transparency and clarity as to role, and it protects the rights of children. Courts will be required, and this is where the shift occurs, from a mandate to appoint a GAL to a mandate to appoint a client-directed counsel. And what you're introducing is a stronger ethical accountability for that attorney to that child through the duration of the process. I want to thank Senator Fitzwater for sponsoring Senate Bill 801 and members of the committee for considering this important legislation.
So I have a number of questions. One of the things that comes up frequently is how does somebody represent a child who's not verbal or has cognitive, minors do not have the same cognitive functioning and ability that adults do. So specific examples that were brought up to my attention were what happens when a child who's being abused, and I'm going to ask, we have testimony about sensitive subjects. We've got some kids in the room, so we're going to talk a little bit in euphemisms. But if a child has been harmed by a caregiver and yet is wanting to return to that caregiver, how do the attorney who represents the best interests of the child address that, and what would be that legal framework?
Certainly. So the legal framework, there are 10 states, to clarify, that have client-directed model. It's considered the gold standard in terms of child representation for a number of reasons. But the issue related to confidentiality and related to, advocating for the child's wishes, the two-step that occurs in jurisdiction, for example, like Arizona, the first is, does the child have diminished capacity? And certainly children of a certain age would have diminished capacity, or children with special needs of a certain variety may have diminished capacity. Once that determination is made, the second step is a substitution of legal judgment, and that is where the attorney substitutes their legal judgment for the child.
So can I interrupt and just ask a clarifying question?
Mm-hmm.
So what they're asked to do then is to take the same standard that's used for any client who has diminished capacity, and that law is pretty well defined and utilized in the state of Missouri.
So frequently in Missouri, you see the appointment of a guardian ad litem. The shift here is they still have an ethical duty to the child.
No, I'm sorry, outside of CAN cases, child abuse and neglect cases, and cases where an attorney is representing a client with diminished capacity, let's say whether it's a personal injury case, for example, or really any number of other areas in the law where the client is not able to have judgment.
Right, a lot of times you see the appointment
Yeah.
of counsel.
And those appointed counsels, we have a body of law of how to handle a client with diminished capacity. It
Certainly we
exists.
do.
Yeah.
And the model related to substitution of legal judgment is also a model that the court could enter in Missouri for children. I mean, what we had essentially was Counsel for Children standards, which clarifies how to handle these circumstances. But I think the other issue that you raised related to confidentiality and zealously advocating for their position really is fundamental, right? Like the child either wants to go back home, maybe, or they don't. And if the child wants to go back home and they tell their attorney that's their objective in this proceeding, that attorney should be advocating for resources for that parent and trying to get the case back on track, if that is their goal.
Even in cases where there's substantiated abuse that's ongoing in nature.
So,
For example, a lot of times we're working in and trafficking cases, and children are often groomed to be comfortable with types of activity that society rightly deems inappropriate. So when we have substantiated evidence of that taking place, how would the attorney approach that case?
Certainly. So in that case, first of
Sorry
all,
if I'm fumbling a little bit. I'm
You're
trying to
not.
make sure that I'm
Yeah,
doing
I
this in
understand.
an age-appropriate way.
I get it. So I think the first nature of that conversation that comes up has to do with disclosures within the attorney-client relationship. And those disclosures, of course, if a child's at risk of physical harm, there are carve-outs and even in current Missouri ethical standards for all attorneys related to if immediate harm could come to that child in terms of disclosures that attorney can make to bridge the attorney-client confidentiality segment. The other issue is if they're advocating for a return to the child, I think that's the attorney's obligation to think about the strategy in order to see that accomplished. But ultimately, it's not that attorney's job to play the judge. And I think that's kind of the lane that we've landed in a bit in the child welfare space in Missouri. It's the attorney's job to advocate for the child's position. This is, again, assuming they don't have diminished capacity. This is also assuming that there may or may not be a criminal investigation, and there's varying standards in terms of accountability for what that would look like. So for that reason, too, they deserve an attorney who can help them navigate and understand, and they can have those confidential conversations about what's really going on in the case. Because I think there's just a profound level of confusion in terms of what these standards are, even maybe what courtroom they're in terms of what's going on.
Thank you. That's very helpful. Does anybody have any other questions? Senator Rader. Top.
Thank you. Thank you so much. I've been doing some reading and research on Oregon's program. Are they the client direct? Do they have the client directed attorneys?
Yeah, I believe Oregon's one of those that have client-directed counsel. I mean, you have 10 that have client-directed counsel. You have 13 that have zero, like not even, they have no attorneys for children. And in between that 10 and 13, you have a range of different other frameworks.
Gotcha. Okay. Thank you.
Mm-hmm.
Any other questions for this witness? Thank you so much. I appreciate it. Anyone else here to testify in support of Senate Bill 801? Don't forget your witness form. Yeah. You want to just leave them on the table?
Good morning, Madam Chair. I want to make sure I modulate my voice appropriately here. Thank you very much for hearing the bill.
The previous witness had a booming voice, so I apologize for asking for a little bit of discretion there. Go ahead.
That's okay. Anyway, I'm Jeff Smith representing Missouri Appleseed. We're a nonprofit organization that advocates for the interests of low-income families with a special focus on families that have some involvement with the criminal justice system. This is not exactly our bailiwick, but we are here supporting this bill for many of the same reasons that the preceding witness outlined. We're very grateful to Senator Fitzwater for bringing this bill forward. Grateful to you, Madam Chair, for making kids in very challenging situations the focus of your legislative work. And our only concern with the legislation, which we've been in communication with the sponsor about, is the location of where the juvenile officers ultimately are housed. This legislation would put the juvenile officers under the Attorney General's office, and we think there may be some other options that may be more appropriate, perhaps some sort of office of parent representation. But overall, we think this bill is a great step forward, and we appreciate the movement from the GAL model towards the stated interest attorney model. Thank you again for hearing my testimony.
Any questions for this witness? Senator Gannon.
Yes, I apologize for being late to the meeting today, and I think I missed some crucial information, but you mentioned moving from the GAL model to over here. So are we doing away with GALs?
So this would
Is that
move-
the purpose here? Or
So, Senator, Senator Fitzwater was talking about changing the GAL system and the child abuse and neglect cases
Okay.
rolling into a child-directed attorney, so the child would have an attorney who represented them rather than a GAL who represented the best interests of the child,
Amen.
only in child abuse and neglect cases.
Amen.
But I think that this witness was testifying about the second piece of his bill, which was moving the judicial officers from the judicial branch into another division of government. And right now, the proposal is into the Attorney General's office. And I think you're suggesting you might have some other ideas, but I don't know which those might be.
Yeah, we're thinking, we want to be in conversation with the sponsor, some sort of Office of Parent Representation. We're not sure exactly where that would best or most appropriately be located, whether in the children's division or where, but we look forward to continuing conversations with the sponsor, and we very much appreciate the bill as a step forward.
I appreciate the bill also. Thank you, Senator, for bringing this bill forward. Your wife did an amazing job on the presentation or testifying. I was going to mention that Daryl Meese, who is from Jefferson County, the governor appointed him the director over the Children's Division, and I have visited with him on several occasions. He has a great story to tell, and when he was a judge in Jefferson County, he told me one time, he said, I always ask the child, what do you want to do? And I think that's so important. And then I look up, and he just walked in the room. Okay? I don't know if he's going to speak or not, but he's just amazing and can shed a lot of light on the situation.
And the legislation is certainly in that spirit. So
Yes.
thank you.
Thank you.
Thank
Yes.
you, Senator. Any
Thank
further
you.
questions for this witness? Seeing none, thank you. Any further testimony and support?
My name is Kathy Haddock, and I'm the Care Community Coordinator for the Coalition of Charities. We have an organization that supports families that are experiencing foster care. Probably more importantly, I am the adoptive mom of 3 adult-sized teenage humans that are currently 16, 16, and 17. I was a foster parent for about 7 years. They combined have about 16 years experience in foster care, which is far too long, which is what brings me to kind of what I do on a regular basis. I currently serve as a foster parent training specialist, and I train foster parents all over the state, including several from Jackson County, so I was interested to hear from you about the effects of trauma and how that can affect the way that children and even families behave. And I think that I think it's very important for people involved in the foster care system to understand that the trauma that's inflicted on children by being in the foster care system, and that if we can keep from separating children from their families, I think that is also very important. My experience with things in this bill with the guardian ad litem issue is that in our experience, guardian ad litems do not have a lot of contact with kids in foster care. My oldest and youngest were in care for over 6 years. I believe they saw their guardian ad litem one time, and they neglected to invite her to the adoption hearing, so they had to call her and have her run over real quick. So I think that there is some disparity in how the guardian ad litem system is supposed to run and how it actually does run in some cases. And sometimes it's because in smaller areas, we just have an unruly amount of cases that are the responsibility of 1 or 2 guardian ad litems. I asked our guardian ad litem in our county once how many cases she had, and she said, I don't like to know the number, and that means it's too high. We can't offer appropriate representation when we have numbers that way. Currently, I'm taking a class with Patricia Crittenden, who has written a paper on the effects of separation from parents on children, and I think it speaks well to reasons why we should leave kids in their homes and provide services to families before separation happens, as well as kind kind of revamping the system altogether so that we support families instead of children, maybe having a less adversarial role, which is maybe not the nature of this bill, rather than a more adversarial role so that we can provide supports for families to make families work, because if trauma happens in relationship, it needs to be repaired in relationship. That's really how that works. So I would encourage you to, when you're doing this bill, to consult that paper. It's an exhaustive review of over 400 different articles.
Do you mind giving us a copy of that? If you're can get it to Senator Fitzwater, maybe we'll be able
Yes.
to get it to everybody.
I gave it to Senator Carter. I emailed it to her last night.
Okay,
but-
great. So
Yeah.
we can just ask Senator Carter to send it around.
Yeah.
Thank you.
Sure, yeah, absolutely. I think that, while I don't agree with everything that Patricia Crittenden says, I think that she has some solid advice as far as looking at a both and initiative. And I think that's really what the senator from Jackson County was talking about, when you have families that are working the plan, that you want to keep families together and work reunification. But at the same time, you have to be mindful of a child clock. And when you're talking about 15 months, when the child is 15 years old, that is an eternity. 15 months old, that is an eternity, and it just can't happen. And I think the other thing that we don't consider when we move towards permanency, my kids were adopted after several years in foster care, is that permanency doesn't happen when you sign the papers for adoption. It's something that we fight for every day, and we continue to do family counseling week after week after week, and we continue to have those conversations to try to rebuild those relationships with their biological parents post-adoption. And I think we need to look into mediation, maybe resolutions, for instead of just doing things in court, so we can work out post-adoption contacts, so that we can have a both and relationship. We have the supports of the foster families or relative families, and we have the supports of the biological families as well. Yeah.
Thank you, Senator.
Just real quick, you have an open adoption with the children?
It is not an open adoption. It was a closed adoption, but I understand the importance of working on that relationship. My kids' parents are relatively safe, and so we do allow contact. My kids are also teenagers. I think a closed adoption is kind of a fairy tale, and we have the internet. They can find them anyway, and I would prefer to be available to them when they reestablish that relationship than to wait until they're 18 and they're gone.
So I
that's
wanted to
something
make
we
clear,
work on.
that's a choice that you made,
That
though,
is a
right?
choice that I made,
But that's
that's
not
correct.
required by the court, correct?
That is not required by the
Okay,
court.
I just wanted to clarify that for those people listening may think that the court is requiring that there be interaction with the birth parents after an adoption. And my understanding and clients that I've represented, that is not a requirement of the court. That is a decision between you, the adoptive parent, and if you want to continue a relationship or establish a relationship with the birth parents.
That is true, but I think that there's also post-adoption contact orders that we can arrange before adoption happens that can allow for those things. Okay.
I agree with you. I'm just wanting I just want people to understand that it's not something the court requires you to do.
Right. And I also it's important to note that I train adoptive parents, and whenever we go through training, I say that it's important to consider what that looks like, because there's a need. There's a need to connect with your biological family, whatever that family looks like, and there's a need to resolve that relationship. And it's very important that kids understand their story, whatever that story looks like. So, and they need to make those connections and be supported in that.
Senator Arthur, did you have a question?
I really appreciate your testimony. I think you provided a lot of helpful insight, and you offer a really great perspective. The thing I liked about your testimony is you offered a lot of solutions, including funding of GALs and a focus on family supports. I guess, and all of that, I think we as a committee should look at and see if there are ways to turn those solutions into legislative priorities. I guess my question is, we have this legislation in front of us, and this would upend and really transform a system. And so I guess if you can speak more specifically to why you think this is the right solution.
Why this particular bill is
Yeah.
the right solution? I think it's not. I don't think there is one solution. I think it's a very small step, but it is a step forward. But I don't think it's the end all be all for solutions. And I think there's also a joke in Children's Division that everything is a multi-year process. And unfortunately, foster care was a multi-year process for my children, and that's not okay. We've got to start moving forward.
Do you see anything in the legislation, and I know that we try to think through all unintended consequences, but do you think, are there any potential conflicts, or is there anything that gives you pause about this bill?
About this particular bill?
Yeah.
I think the verbiage that was used earlier about an adversarial role, a more adversarial role, and I think the focus on the children's needs, I think is maybe a little bit premature. I think there needs to be a more centered focus on the family's needs, because if we can get reunification, then we need to get reunification, and we need to have services to support that. So I think that's probably the only thing that gives me pause, but I think it is necessary to revamp the current system because children are not getting represented appropriately, and I think that probably leads to not ending cases after 15 out of 22 months or moving towards termination of parental rights after 15 of 22 months because we can't guarantee that parents have had adequate services. And so if we have appropriate representation, then my hope is that those attorneys will say, these parents need access to adequate services. What are we doing? And sometimes it's a matter of the services are available, but they're not being authorized. So maybe we have, with the CTS contract, that those services are not being authorized in an expedient fashion. Maybe because we don't support that 15 out of 22 months, parents don't have that accountability. They think that they have forever, so let's take forever. I've had friends that have had their kids removed and returned, and they said, they told me I had 12 months to get my kids back, and I believed them. So every day I worked on it. Sometimes when we tell parents they have 15 out of 22 months, but then they see kids that have been in care for 14 years, they don't believe that. And they shouldn't, because they don't follow that.
Well, thank you very much for your testimony.
Thank you, Senator Carter.
I just wanted to thank you for coming down. I know her personally. She's just been such a huge asset in our community and beyond. Because of conversations I've had with you prior to even being a member of this body, I reached out to a couple of the judges, and they're spot on. The one who, and you might know his name, but the one who says he's had the most recorded reunifications with parents has been the judge who, when the parents are sitting in front of him in his courtroom, he says, why haven't you done your drug testing this week? Why haven't you done this and this? And therefore, what do you want me to tell your son? Because he doesn't have you don't have visitation now. And he said it takes a little bit of that approach to kind of push, especially when you're talking about opioids and other addictions now. These are not things that you can just flip the switch on. And so there has to be a little bit of mentoring, but also you have to have judges who are willing to kind of help those parents realize that this is a real issue and that their TPRs happen, right? So I just really appreciate your testimony, Kathy. Thank you.
Yeah, I definitely think there needs to be that accountability, but you have to have, trauma-informed care means that we not only have that structure and accountability, but we have the scaffolding and supports to help them achieve those goals. And we already know that these parents can't do it. So why are we not giving them supports and expecting them to do it? That's the definition of insanity. If we're expecting them to meet these high expectations of good enough parenting, whatever that looks like, we do need to give them the supports because they obviously didn't do it before. We can't just expect them to do it on their own.
Thank you very much. I appreciate your testimony. And as a mom who navigates open adoption with my kiddos' families, I just want to say for people who are listening, it's true that it's not required legally, but it has been a wonderful gift in both of my children's lives and the rest of our entire families. And so thanks for helping train families on how to navigate that. So thanks. Anybody else in support of the bill? Okay, anyone in opposition? We've had a really wonderful conversation thus far, and I don't want anybody to feel rushed, but I lost track of time, and we still have one more bill to present, and so I'm not going to rush anybody, but I just want to let everybody understand. Luckily, the chairman of the next committee has graciously allowed us to have a few minutes, maybe of the next hearing, but we're going to try to make sure we get both bills And
Absolutely. And
thanks.
thank you for allowing that, Senator Arthur. So I am here technically in opposition of Senate Bill 801, though I represent myself as an attorney who practices representing moms in juvenile cases, dads in juvenile cases, children as a GAL in juvenile cases, grandparents occasionally when their placement and they come into the case are allowed to interplead into the case. So I've represented everybody but the state, basically, in juvenile cases. And the group that I'm with, MAFLA, Missouri Association of Family Law Advocates, has been trying to work for several years with several senators and representatives on this legislation to try to improve the system. We agree that the system is broken. We agree that the system needs changes. We agree with a lot of the things that are said today. We don't agree that this bill actually does those things and makes those changes. We talk a lot about reducing trauma. I don't disagree with anything that anyone has said about reducing trauma on children. The best way to do that is to reduce the removal of the child in the first place. This bill doesn't do anything to provide services to counties, juvenile offices, judges, or parents to help reduce removal in the first place. If we can stop the kids from being removed by offering family-centered services cases through Children's Division before we have to get to the juvenile office and file something, then we've already reduced the trauma because the kid's still in the home with their parent. We have something we do here in Cole County where if you give birth to a child and then you and that child are addicted to drugs, we do not automatically take that child. That is harmful to the child. You don't get that bonding. That is harmful to the parent. What we do is we put services in place in the home because our juvenile office has offered to come and help do that and have someone in that home every 24 hours to check on that baby and to make sure that mom isn't using, and let's say it's usually mom, dad isn't using, and that baby is safe. So they still have their bonding because you can't bond with your newborn 1 hour a month or a week. You can't do that. This bill doesn't address any of that either. How to reduce removal. One of the issues we have that several people hit on is guardian ad litems not meeting with their clients in juvenile cases because they have huge caseloads. That is an attorney issue. So whether you call them a guardian ad litem and they follow those standards, or you call them the attorney and they follow the ethical standards of an attorney representing an incapacitated person, which is different for a child than it is for an adult with schizophrenia or something, you're talking about the same pool of attorneys. You're not talking about different people. So if you're unhappy that Bob and Joe, the GALs, aren't doing their job now, well, Bob and Joe are going to be the same people assigned as the attorneys in these same small counties that only have 3 people doing GL work or 1 person doing GL work. You're not adding a pool of attorneys by changing the name. So that bill doesn't fix that issue either. Also goes to a training issue of judges. I think you hit on this. This bill doesn't address training of judges, which I realize is in front of the judiciary because the Supreme Court has to do that. But gosh, you guys could put a funding line in there for OSCA that says this is for judicial training for juvenile judges. You have that ability to do that. Why we're talking about funding, I don't know what the bill sponsor means when he says judicial officer. I think he's talking about juvenile offices, but that's not clear because technically I'm a judicial officer. I'm an attorney. I'm a lawyer of the court. The bailiff is a judicial officer. Judge is a judicial officer. Juvenile officers are judicial officers. We need a little more definition on that. Also, the juvenile office has a juvenile officer, and then usually a secondary juvenile officer, and then a whole bunch of deputy juvenile officers, and then 1 or 2 attorneys. And those 1 or 2 attorneys go to court and do the things. The juvenile officer is not the one who is leading the litigation. The juvenile officers are not attorneys. They are typically social workers, mental health professionals. They have training in, taking care of families and kids and things like that. And they work through the juvenile office somewhat as a case manager, much like the Children's Division worker. But now it's gotten past Children's Division. We've got to go to court. We're doing more now than just the family-centered service case, as they call it, which is where you are just providing services to prevent removal. Now we've got juvenile office involved. So if we're talking about moving the juvenile office to the AG, which we think is a very bad idea for a number of reasons, who is that? Is it just the lawyers? Is it the lawyers and the juvenile officers? Is it their whole staff? How is that covered? Assuming that it is the whole staff, just to move the Jackson County, St. Louis County, and St. Louis City juvenile offices to the AG's office will cost the AG's office an additional $85 million a year. That's just 3 counties. And you guys know how many counties we have in our state. That's just 3. Plus, you've got a conflict of interest issue because the AG's office represents all state agencies. That includes Children's Division. Children's Division and the juvenile office are not always on the same page. There's often a lot of conflict out there. So if you've got the juvenile office in with the AG, you've automatically got a conflict when the 2 parties are not in agreement when you get before the judge. So I think there are other ways we can do that. And really, finally, we have no mechanism, and I know it's difficult for you guys because this is all funded through the county. So presuming that these attorneys you want to appoint instead of GALs would be funded through the county, just like the GALs are. Counties also spend those funds, though they're not specifically allocated. They will take those funds allocated for GALs, and they will also use them, pay the GALs less so that they can pay attorneys for parents, because that is so important for the parents to have an attorney. Because what we're talking about here is a lot of advocacy to get the kids home. And I heard several people say the attorney for the child can advocate for the parents to get services. That really isn't that person's job any more than it's the GAL's job. That would be the parent attorney's job. That's what we need. This bill doesn't address that either, and I realize that's an issue with unfunded mandates and sending things to the county, but I believe there's a way we can work around that. We can look at that and figure out how we get these parents attorneys in the counties that don't have them. Cole County does it, Boone County does it, Callaway does it, Stoddard County, and several places in southeast Missouri do it. Jackson, Clay, St. Louis City, St. Louis County, all of those places do it. It's something that can be done. And so I would appreciate, I would like to work with you guys, and I would know everyone here would like to work on trying to really fix the issue of the trauma we're causing kids by removing them and helping parents advocate for themselves by giving them an attorney so that they can get their kid home faster. And finally, last but not least, this bill does not address for either GALs or attorneys for kids to have trauma-informed training. We have to have certain training. Our guidelines, the GAL guidelines have certain training, and it says specific things. Trauma-informed training is not one of those. I have trauma-informed training. My mother worked with domestic violence victims my entire life while I was growing up. I sought that out for myself. I offer that to other people. I set that up with a wonderful therapist. So I know I need to wrap up. So I would suggest we throw training in there regardless of what we call them, is you guys have the ability to do that, to make sure that attorneys who work in juvenile law have trauma-informed training.
Thank you for your testimony. Any questions for this witness? Senator Carter.
So as it's set up now, and my understanding is that the juvenile officers work with the Children's Division as a checks and a balance, so to speak. So when there potentially is harm,
Right.
you're working together to make sure that the JOs know that the kid can stay in care. Is that accurate or not?
What do you mean the kid can stay in care?
Well, the kid can stay home
Stay
or
home.
should be taken into care.
Yes.
That's a decision maybe between the JO and the Children's
Yes.
Division.
Usually what happens if there's a hotline call, Children's Division takes a hotline call, an investigator goes out and investigates. If that investigation is substantiated, then they go back to Children's Division, and Children's Division decides, is this a case where we need to make a referral to the local juvenile office to file a petition, or is this a case where we can do what's called a family-centered service case, FCS case, where we in-house can meet with the parents, provide services without going to now the juvenile office is probably still aware, at least in our county and Cole County, they communicate very well with each other. But they've not been asked to file anything. It's not before the judge. CD is trying to work with this case, and it's a different worker than the investigator. There's investigators and the caseworkers, 2 different people.
Senator, I apologize. We're supposed to be leaving right now. We have another bill that we still need to present. Can we
I'm
connect
happy to talk
offline?
to you.
Offline. I'd
Absolutely.
appreciate that.
Happy to
Yeah.
talk to you
Thank
about
you
that.
so much. Is there any other any questions that we could, thank you so much for your testimony.
Thank you.
Anyone else in opposition?
Good morning. Still morning. Good morning, Madam Chair, members of the committee. My name is Marcia Hazelhorse, and I am the Executive Director of Missouri Juvenile Justice Association. And we are here to actually testify in opposition of Senate Bill 801, in particular to the provision moving the juvenile officer from under the judiciary over to the Attorney General's office. We have had the opportunity to sit down with Senator Fitzwater as well as Madam Chair and had some discussion, trying to flesh out details, numerous questions that we have, several of which the former witness has already raised with respect to the juvenile officer. So we really appreciate the opportunity to continue to the discussion so that we can work on whatever structure is best for the children and families that we serve. We certainly don't want to do more harm than good, and I've heard that repeatedly from everyone that's testified. This is about improving services to children and families that we all serve. And so I just want to, in closing, just want to mention that, juvenile officers are involved in much more than just child welfare cases. We serve a significant role in child welfare cases by not only being the petitioner, but we also serve on the family support team, as well as a multidisciplinary team. And then juvenile officers are also charged with supervising youth who have committed delinquent offenses, status offenses, as well as arranging programs and services and all the things that would help them to be successful within our system. So again, we appreciate the opportunity to continue to work with both the senators, as well as all the body in this committee, and I'm happy to answer any questions.
Thank you for your testimony, and thank you for your willingness to continue discussions and trying to find a solution that works. Okay, thanks. Thank you for your testimony. Anyone else in opposition? Anyone for informational purposes only?
Hi, good afternoon. My name is Heather Vodnansky, and I live in Central Missouri. I'm a foster parent. My other hat that I wear is I'm a criminal defense attorney. But today I am talking informational only. I've been a foster parent for over 6+ years. My family decided to do this to do what we can to help others. And as a foster parent, we have seen both sides of this. We have taken kids in that were very, very young, and we have taken them while their mothers were able to successfully complete treatment, successfully find housing, and were able to be reunified. We still keep in touch with those kiddos. We've seen these great outcomes. We've also seen the other side. We are one of those cases where I've had a placement for over 4 years. I've had a child that's still deemed a foster kid. She hasn't had contact with any bio parents in probably 5 years. So I've had both sides of this. And I think that this system is set up to reunify and keep the family together. And I think that that's correct. But I also think if the family structure isn't working, the permanency that is delayed is permanency denied. And that's not fair to our kids. So while I don't agree with everything in this bill, I do think that it's a wonderful conversation starter. And I think that it must happen, and there's no time like the present to get this conversation going. I think that the Child Protective Services are a very localized issue with localized solution and localized sources. So when we talk about a state agency like the Attorney General taking that over, I think that that's highly inappropriate. I think that, whenever you have a team meeting and you talk about how someone needs to get a drug test and that needs to happen in the next 2 weeks, it's helpful when you have a local person to know where to take somebody, where to tell them to go so that they can get that accomplished. This helps everyone. What I've seen in some of our juvenile cases
I'm so sorry to interrupt you, but we are out of time and we're going to need to move on to the next person for informational purposes.
Okay.
Do you mind making sure that Karen has your contact information, and we'll include that so people can follow up with the committee?
Yes.
Thank you so
Yes,
much.
thank you so much.
Anyone else for informational purposes only? there's not much time to give us information, and I apologize for the mismanagement of time from the chairperson. If you're able to just go on the record for informational purposes, and then we'll go ahead and get your information to the rest of the committee about who you are so we can ask follow-up questions, or if you wanted to send an email, that'd be exceptionally helpful.
That's absolutely fine, and I appreciate that. Just a brief introduction and a couple of highlights about what I appreciate. My name is Claire Terabon. I am here on behalf of Jackson County CASA in Kansas City, Missouri. I think it was mentioned we probably have the most kids in foster care in Jackson County. Jackson County CASA is a unique program in that we have our traditional CASA model where we have lay advocates that represent kids, but we also have a legal department with guardians ad litem that represent about 50% of the kids in foster care in Jackson County right now. So I'm here and I'm happy to talk to anyone about any of these things.
Thank you. And if you'll just make sure that we have your information and leave your form there, and I hate to cut you off, but I think that we have one more that needs to leave their information as well before we present Senate Bill 811. So thank you so much.
Appreciate
Anyone
it.
else for informational purposes only, please come forward. Yes, ma'am.
Hello, I'll be
Thank
very
you.
quick. My name's Katie Velasquez. I'm with Family Advocacy Solutions. So I have a small agency in Southwest Missouri. We actually are unique in the fact that we serve bio families. So we work all those reunification efforts, and we also hold contracts when we work with foster parents. I'm also a foster adopted parent. So I have a lot of things that we could talk about as far as reunification with parents and where we drop the ball. When we talk about timelines a lot of the time, I think what we need to consider is a lot of our parents, we're in the system. I had a conversation with a parent on the way up here, and he said, this is my third time dealing with Children's Division. When I was a child, my child that was TPR'd, and now this baby that I have in care. I'm doing all the things, I'm doing great, but coming to the table and having a conversation with a caseworker is hard for him.
And if you wouldn't mind to send, and if you don't have this typed up to where you could leave it for all of the committee members, if you wouldn't mind to send an email to Karen with your full testimony, that way we can get your experience and knowledge on what you had intended to tell us about today.
That's fantastic.
Because I know that would be very, it would just be very helpful.
Well, thank you to Senator Fitzwater for introducing this bill.
Thank y'all so much. And more for informational purposes only?
More for informational only. Just by introduction, Eric Jennings, Government Relations Counsel for the Supreme Court, here on behalf of the Judicial Conference of Missouri. We do have quite a bit of feedback that we've been trying to provide to the sponsor and also to the chair, and we are available to all the members of the committee to let them know what additional input we have.
We appreciate that. Thank you so much. This concludes our hearing on Senate Bill 801. We will now move to Senate Bill 811. Madam Chairman, we
Thank
are
you,
ready
Madam
when you
Chairman.
are.
I apologize to the rest of the committee for the mismanagement of time. I promise this won't happen again. I'm here to present Senate Bill 811, a child protection kind of catch-all. It has a number of provisions that have been introduced in past years. They are, to my knowledge, all completely uncontroversial. And I think you have a number of people who'd like to just go on the record in support or in opposition or for informational purposes. The summary is pretty brief, and all of these issues have been before this committee in prior last year. So happy to follow up if anyone does. Thank you.
Do we have any questions from the committee? Senator Moon?
Just briefly. Sorry, Senator Washington.
Sorry.
That's all right. I don't remember seeing last session the metachromatic leukodystrophy inclusion. And
I apologize. You're right. I'm so sorry. That piece is new, and then there's also a contracting piece that's new. Okay. I have a constituent in my district, actually a former opponent that attempted to run for the same seat, who's been an incredible guy, and he had a friend, dear family friend, who had this diagnosis, and asked that it be included in the newborn screenings, and I made a commitment that we would add that to the bill. I am so sorry. I did not mean to misrepresent that.
That's okay.
It just, in the
the question I had, though, was, if I'm not mistaken, this is one that's genetic?
Correct. It's another genetic.
And so I'm not sure if there's a reason or that would have merit to just have that as a broadly applied newborn screening. So
no, and I appreciate that. My understanding is that this particular diagnosis is not, it is often undetected. And
Yeah.
so when people know that they have it, they're able to get preventative treatment. But I think that's a valid concern, and we can certainly talk more about that.
Yeah, and unless I'm off base, I don't think there's a cure yet. There is some treatments, but it doesn't really change the outcome greatly. But I'd like to talk to you more about it, perhaps. Thank you.
Absolutely.
Senator Washington.
Yeah. I want to follow up on that a little bit. This would be a similar screening like sickle cell anemia, which is at birth for African American children, any children that have African blood.
It
Right.
would be an additional infant
Right.
screening.
So, and just to help Senator Moon, so although that is also genetic, we still test that because while your parents may not have it, there may be someone in your past that you may not know, and that gene could be pulled through. So that's why you're asking for this to happen at birth, right?
That's right. So early diagnosis is key to improve outcomes. As Senator Moon stated, there is no cure for this, but there are some promising treatments that parents, if they choose to provide for their children, can reduce the negative outcomes.
Okay. And I thought you were done, so I didn't bring my notebook back, but it seemed that one of the things that I don't remember from last year was a little bit, it appears to be lessening some liability on the part of state employees.
No,
with
it's a
respect to
clarification.
damage.
No, it's a clarification. So what's happening is the providers would still be liable for, and that was filed as an amendment, but not a standalone as one of the other, I'm pretty sure. But what happened is happening is that there's a contracting problem where the state is trying to offload the state's liability onto children's basically providers and children's contracts. So rather than saying you're liable for whatever actions you take, which is perfectly appropriate, they're having to assume liability for state action for which they cannot control, which means that we will have no one who will bid at that work anymore. So it's
Okay.
providing clarification that everyone is liable for everything that they do, but I'm not going to be liable for your actions. You're going to be liable for your actions, and I'm going to be liable for my actions.
Okay.
Thank you, Senator.
Thank you. Any other senators wish to ask the sponsor? Okay, seeing none. Anyone in favor wishing to come up? Please do.
Madam Chairwoman, members of the committee, Organ Schlemmer on behalf of the Missouri Coalition for Children. The senator talked about one of the key pieces on the liability. We will send in writing our support for those provisions to the committee.
Excellent, thank you. Anyone else wishing to testify in favor? Anyone wishing to testify against? In favor? In favor. Okay.
Thank you, Madam Chairman. David Willis, registered lobbyist on behalf of KVC Missouri. We're a child welfare foster agency kind of across the entire spectrum of child welfare. Just want to go on record in support and thank you for Senator Coleman for including the Children's Division contracting language. We've been working with her on for a couple of years.
Excellent, thank you so much. Any questions for this witness? Sorry, I should have asked that about the previous witness. Seeing none, thank you.
Thank you.
Anyone else wishing to testify in favor? Anyone wishing to testify against? Anyone wanting to speak on informational purposes only? Seeing none, this concludes our hearing on Senate Bill 811, and this concludes our hearing today in Health and Welfare. Thank you. What committee are we?